welcome to my YouTube channel, Official Joel TV. On today's episode, we'll be talking about the legal relationship between ownerless properties and the act of stealing. Generally, for there to be the offense of stealing, the subject matter must have an owner. As such, ownership is an important element the prosecution has to prove beyond reasonable doubt before an accused can be convicted for the offense of stealing. Unfortunately, neither the criminal code nor the penal code mentions ownership. The word has generally been said to have been included by the court. It has been settled through judicial pronouncement that anything capable of being stolen must have an owner. Nikitobi JCA, as it then was, in Onogoruwa vs. State, stated the importance of ownership in the offense of stealing, where the learned jurist opined that ownership is the most vital and indispensable essential ingredient of the offense of stealing. It is upon this ownership which all other essential ingredients stand upon. Therefore, it is the baseline of the offense of stealing. The consequence of the aforementioned provision is that property without an owner cannot be said to have been stolen. Putting it in context of if someone sees money on the floor on an empty road and takes it, can it be said to have stolen it? Well, morally yes, but legally no. The concept of ownerless property has been statutorily provided for in section 383 subsection 5 of the criminal code, which states that when a thing converted has been lost by the owner and found by the person who converted it, the conversion is not deemed to be fraudulent if at the time of making the conversion, the person taking it or converting that thing does not know the whereabouts of the owner, and he believes on a reasonable ground that the owner cannot be found. Well, if at this point you satisfy the provision of section 383 of the criminal code, then this conversion of yours can be said to be legal. That is, if you don't know where the owner is at the point where you are picking up such item you are hoping to convert. Hence, it can be reasonably inferred that a person who picks up 1,000 naira notes in front of the lecturer's office a few minutes after the lecturer entered his office with the intention of converting it may be said to have stolen it, because there is a reasonable ground that the money might belong to the lecturer. This same decision is likely not to be reached if the money or any other lost object is found in an empty road, bush, lecture theatres, or in an isolated environment. In conclusion, the principle of law under the Nigerian criminal law jurisprudence is that the finder of lost property cannot be legally considered to have stolen the property. Well, morally, we will agree otherwise, but this should not be the concern, since morality does not win in court. To this end, I believe we now understand the difference between conversion and stealing. Conversion is legal while stealing is illegal, and finders are truly the keepers. This is Official Joel TV. I do videos like this. Please subscribe to my YouTube channel to watch more videos like this.